Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Sir, I believe there'll be some short questions from the NFSP.
Yeah.
Can you see and hear me now? Is that fine? Brilliant, thank you. Good afternoon, Mr. Cooper. My name's Rohi Shah, and I represent the National Federation of Sub-Postmasters. I'm going to refer to some sections of your witness statement. There's no need to turn it up unless you wish to review them. At paragraphs 13 to 14 of your witness statement, you refer to your role on the Nominations Committee and explain that this committee dealt with senior appointments at the Post Office. As a member of the Nomination Committee, and given what you've said today about the conduct of the litigation, did you or anyone within UKGI suggest that any board member or senior management members of the Post Office resign following the judgment of Mr. Justice Fraser?
Yes, absolutely. Yes, I mean, Jane McLeod was asked to leave the company.
And other than Jane McLeod, was anybody else discussed?
No, the priority then was to change the legal team and get new advisors on board.
Okay. At paragraph 252 of your witness statement, you referred to a board meeting on the 26th of November 2019, at which it was confirmed that the Common Issues appeal decision had gone against Paul, and that it was now necessary to implement the findings of the Common Issues judgment in full, including asking sub-postmasters to sign new contracts. However, postmasters were never asked to sign new contracts, and the NFSP were never informed that it was considered that postmasters should sign new contracts. Could you explain why that was?
Yes, I can. So I think the initial advice that Post Office got and the board got was that postmasters would need to be asked to sign new contracts. I think the team led by Nick Reed considered that, and I think the practical answer that they came up with was for the company to restate all its policies in relation to how the contract would be, the existing contract would be interpreted. So there were new policies issued around things like termination, suspension, investigation and disputes, all those issues that came out of the Common Issues judgment. And so effectively, Post Office said unilaterally, we are going to interpret the contract in a way that's compliant with the Common Issues judgment, and that avoided then the need for postmasters to sign new contracts.
And finally, in terms of finances in the future, would you accept that Post Office will likely never be able to afford the costs involved of the Horizon scandal in terms of administration and redress without ongoing financial support from the government?
Well, never say never. But I think certainly at the time I left the board, which was over a year ago now, I think it's clear that Post Office would not be able to, it's abundantly clear it wouldn't be able to afford the cost of the compensation, and the ongoing business model was unsustainable financially, yes.
Okay. Thank you very much. Those are my questions.
I'm very sorry. I'm very sorry that, hang on, I seem to have disappeared. No, here we are. I'm very sorry that I asked you to wait for 45 minutes for delivering those. If I had thought that you'd have been as short-winded as that, I would certainly have permitted you to ask the questions before lunch. So my apologies.
Thank you, sir. I have some very brief follow-up questions, please, if I may. Mr. Cooper, I'd like to briefly revisit the issue of the department's level of engagement in the group litigation. Could we look, please, at what you say about that at paragraph 80 of your witness statement? Page 39, please. Thank you. You explain in the preceding paragraph, paragraph 79, that the department had the same rights as UKGI in relation to receiving information and reports from the Post Office concerning the litigation. Is that right?
That's what I believe the protocol said, yes.
You go on to say at paragraph 18, in practice, however, it was made clear by the department that it expected UKGI to take the lead on monitoring the litigation and keeping the department informed. As I explained below, the department was provided with regular updates throughout the litigation. My perception was that the department was interested in the progress of the litigation and wished to be updated, but did not envisage playing an active role in the oversight of the proceedings. So this is reflected in the readout from the quarterly portfolio review meeting on the 5th of July, in which it's recorded that whilst it was UKGI's view that the department's legal team should be involved at every stage of the litigation, securing such a level of engagement may be a challenge. Do you consider that you were hampered in your oversight of the group litigation by the department's refusal to engage more meaningfully as you saw it?
Sorry, was my effectiveness hampered?
By your perception that the department were not engaging more meaningfully?
I think the department could have been more effective on areas where I thought it would matter to them, yes. Had they been more involved. And as I said earlier, I think the absence of meetings to talk about this, the litigation, was regrettable.
You go on to say in the same paragraph that, as I explained below, there was a step change in the active interest from the department following the hand down of the Common Issues judgment and the subsequent progress towards settlement, but with the exception of the meeting between Post Office, the Minister, the Permanent Secretary and others in October 2018. Prior to that, the model was largely one of UKGI providing the department with progress updates. I just want to test with you briefly whether your recollection in relation to the timing of the department's intervention is quite right. Could we look, please, at UKGI 408656? Thank you. This is a summary of a meeting which you attended with Kelly Tolhurst on the 19th of November 2018, produced by an official in UKGI. It reads, we had a meeting with Kelly Tolhurst this morning. Tom C., presumably that's a reference to you, dialed in, while Sam W., Sam R., and I were in attendance. It goes on to say Kelly had concerns over Post Office's potential liabilities over the court case. She was sorry to hear Paula is leaving, but suspicious about the timing given the ongoing litigation case, and asked about the progress for getting her replacement. It says, keen to be properly briefed as the litigation case progresses, and would welcome both verbal and written updates on a bi-weekly basis. She would also welcome a face-to-face meeting with Tom C.
Okay, thank you. Yes, so I understand what you were saying earlier now. So I think firstly my witness statement is accurate because the period I was addressing in my witness statement was up to October 2018. This email is in November. So I think that meshes, that's consistent. But you're right, I had said earlier I had no recollection of Kelly asking for more information until March 2019, and you're right, there's evidence here that she was asking for it earlier.
Thank you. Finally, I'd like to ask you some brief questions about the department's reaction to the Common Issues judgment. You addressed these at paragraph 170 of your statement on page 80. Thank you. So that reads, the Common Issues judgment was formally handed down on the 15th of March 2019. On the same day, there was a meeting for Post Office to brief departmental officials. The ministerial briefing to which I referred in my email to the board took place on the 16th of March, the day after the judgment was handed down. I recall the department being very concerned about the judgment and what could be said publicly in response. During the course of the briefing, I recall the Secretary of State, Greg Clark MP, making a comment to the effect that he had always believed the sub-postmasters were right and that it was now important that these cases were resolved as quickly as possible. You then go on to say, I'd not previously heard those views expressed by the Secretary of State or anyone else in the department. You appear to be suggesting at various points throughout your statement that the handing down of the Common Issues judgment marked a turning point in the department's engagement in the litigation. Is that fair?
Yes.
Were you emboldened by the intervention of the minister to take more decisive action in your oversight of the litigation?
Not really. I felt I was engaging with the litigation in the way I thought it was appropriate for a non-executive and a member of the shareholder team. I don't think I was particularly... I mean, the Common Issues judgment was a massive event and it needed to be fixed. I don't think I needed Greg Clark's views about the litigation to change how I approached that. My point in relation to his views were that I think they, had I known, it possibly might have made a difference before the Common Issues judgment, and I think might have made me more challenging in terms of what I was hearing from the postmasters. I mean, it would be good to know why he thought the postmasters were always right, and I'd perhaps, you know, that would have been good to get as to help me. So my point was in relation to pre-Common Issues rather than post.
His intervention coincided, did it not, with your decision to initiate discussions with the chair about the replacement of the Post Office legal team?
Yes, but they're not connected. I'd formed my... I think I explained earlier the first board meeting after the Common Issues judgment was handed down and the interaction I'd had with Jane McLeod at that meeting. And I said earlier that something to the effect that at that point I'd lost all faith, whatever faith I had left in the legal team. And it was off the back of that that I felt it was imperative that the legal team was changed. And that prompted me to discuss it with Tim Parker, and we got on quickly with making that change. So that would have happened independently of whatever Greg Clark had to say on the topic or not.
Do you consider the department was in any way instrumental in bringing about a change in strategy within the Post Office in respect of the litigation?
No, because I think everyone was completely aligned. I mean, the department was and the board were in the same place. Something had gone badly wrong. It needed to be fixed as a matter of urgency. Where I think, had the department said, hang on a minute, we don't want you to settle with the claimants or, spin this out as long as you spin this out as long as you can, whatever. If they'd had a different motive or agenda from the company, then the department's views would have made a difference. But I think all of us were completely aligned in what we wanted to happen afterwards.
To whom, therefore, do you credit the significant change in litigation strategy which resulted in a settlement of the group litigation later in 2019?
Sorry, say that again.
To whom do you credit the change in litigation strategy which resulted in the settlement in late 2019?
The board. The board. This had gone badly wrong. It needed to be solved. The claimants were right. Post Office was wrong. It had to be settled, and the people affected had to be compensated.
Thank you. I've got no further questions.
Thank you.
Just before you finish, Mr. Cooper, at various points in your witness statement, you suggest that post office executives thought that your approach to your role as a non-executive director was a bit too inquiring and a bit too interfering. Can I just try and get some detail of that? First of all, was that something you felt almost from the beginning of your role as a director, or did that sort of emerge as time went by, so to speak?
No, it was pretty early on, Sir Win, and you know the kind of formal feedback I got through Tim Parker to Mark Russell came, I think, in the summer of 2018, but it was clear earlier on that some of the individuals we dealt with in the company were not happy with the way, with what we were trying to do.
All right, and can you actually pinpoint any individuals who made that clear to you?
I think, if I can say, the communication of it came more through actions than words, or responses to requests, and I think that the issues we had were with predominantly the legal team, with Jane McLeod and Rod Williams primarily, and you know there were specific issues with the finance team, with Al Cameron.
Right. All right. Thank you very much. Well, thank you, Mr. Cooper, for your detailed witness statement and for giving evidence during the course of this morning and into this afternoon. I'm grateful to you.
Thank you.
So, Ms. Hodge, I won't disappear. I don't think I need to disappear. I'll just wait for the handover.
Thank you.
I see Mr. Stevens is in pole position next to you, so we'll
Ready to go.
go.
Thank you.
Good afternoon, sir. Can you see and hear me?
Yes, thank you very much.
So we'll be hearing from Mr. O'Sullivan.
Yeah.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you very much.
Thank you. Please, could you state your full name?
Patrick Henry O'Sullivan.
Thank you, Mr. O'Sullivan, for giving evidence today to the inquiry. And thank you, too, for producing a written witness statement, which should be in front of you. Is that in front of you?
Yes.
For the record, that witness statement is reference number WITN 110000100. Now, before I take you to your signature, I understand there's a correction to be made. Please, could we bring up page 2 of the statement, paragraph 5. So in paragraph 5, there are two corrections to your qualifications in the second sentence. I believe the first is that the words arts in should be removed, so it just says Bachelors of Business Studies. Is that correct?
Correct.
And secondly, the words Masters of Economics should be removed, and in place it should read MSc in Accounting and Finance.
Correct.
Thank you. That statement can come down now, thank you. Can I ask you, please, in your hard copy, to turn to page 23?
Yes.
There should be your signature or a DocuSign version of it. Do you see that?
I do.
And it is your signature, is it?
Yes.
And can you confirm, please, that the facts stated in that witness statement subject to the corrections we've just made, are true to the best of your knowledge and belief?
They are.
That now stands as your evidence to the inquiry. The statement will be published on the inquiry's website shortly. I'm going to ask you some questions about it. I'll start with your background. You trained as a chartered accountant, is that right?
Correct.
During your career, you worked in a number of executive positions at various financial institutions.
Correct.
You began to undertake non-executive roles in 2007.
Correct.
And your last executive role was as Vice Chairman of Zurich Financial Services, which you resigned from in 2009.
Correct.
Since then, you focused on non-executive roles.
Correct.
You nodded. Yeah, thank you. You became non-executive chair of the Audit Committee of the Bank of Ireland in 2009.
Correct.
And you became deputy governor of the same institution in 2011.
That is correct.
You stayed there until 2015.
Yes.
In your witness statement, you say that the time commitment for the role of deputy governor was 1 day per week.
That expanded depending on the need at the time. Could have been
anticipated my next question. In practice, how often did you, on an average week, spend working on as deputy governor?
2 days a week.
2 days a week. You were appointed as a non-executive chair of Old Mutual PLC in 2010.
Correct.
And in your witness statement, you say that the time commitment for that was 4 days a week.
That is correct.
And in practice, how much time did you need to spend on that?
3 days a week.
So less time than, okay. From 2013, you were chair of Lloyd's Syndicate 218.
Correct.
Do you remember roughly when in 2013 you started that role?
I believe it was September.
September 2013. And what was the time commitment for the Lloyd's Syndicate role?
1 day a month.
And did that translate into how much time you actually spent on it?
It did, except for the occasional phone call, etc.
So you were appointed to become the chair of the shareholder executive board. Well, you were appointed on October 2011, but you started that position in March 2012.
That's correct.
In your witness statement, if you could bring it up, please, paragraph 6, page 2. So in the middle, we see it says the Secretary of State, sorry, before there, we see you refer to the Deputy Governor role. Then you say the Secretary of State appointed me as chair of the Shareholder Executive Board in October 2011 with a start date of March 2012. The time commitment for each of these roles was 1 day a week. Now, pausing there, I think you said in practice that was 2 days. And 2 days a month, respectively. So your understanding, well, what you're saying in the witness statement is the chair role took up 2 days a month. Is that right?
No, excuse me, that's technically incorrect. It was 1 day a week.
1 day a week. That statement can come down, thank you. Did you have sufficient time to commit to shareholder executive, given your other commitments to Old Mutual and the Bank of Ireland?
Yes, I put in the extra time to the extent that it was required, at weekends, evenings, or whatever.
At any point, did you feel that you were in conflict in the sense that you had too many tasks for different companies?
Well, jumping ahead, that was one of the major reasons that I did not extend beyond September of 14, because the intensity of the work with Old Mutual was exceptional at that point.
Did you feel that you were able to honour your commitment and the time required to the role as chair of SHEX?
Yes.
Let's look then at the role of SHEX, please. And actually, if we can bring back up the statement, page 10, paragraph 26. It says that I am asked to address matters that go to reporting and risk structures within SHEX. These evolved over time, and I understand the evolution of these matters will be addressed fully by other UKGI witnesses to the inquiry. I think you may be referring to Mr. Russell, who appeared yesterday, and witnesses next week. Is that right?
That's correct.
Would you agree that one of the core roles of the executive of any body or company or government department is to identify, analyse and mitigate risk?
Yes, it's among the important governance requirements of any executive team.
In respect of SHEX, the executive were required or needed to take steps to identify, analyse and consider mitigation for risks of its assets, such as Post Office Limited. Would you agree?
I do.
Whose responsibility was it to carry out that risk management?
That was the responsibility of the team specifically within SHEX reporting to the CEO.
I want to look at the SHEX board now, of which you were the chair, and focus and look at how what its role was in respect of risk management whilst you were there. Please could we bring up UKGI 30-41953. This is a paper on the SHEX board's remit, which I understand was prepared by your predecessor as chair. Is that right?
That is correct.
And we don't need to bring this up, but at paragraph 18.2 of your statement, you say that you think this document fairly reflects the role of the board of SHEX.
That is correct.
And in particular, you refer to paragraphs 6 and 7 of some terms of reference which are appended to it. I want, if we could look at further down the page, please. Paragraph 7 is quoted there. And it says, of the existing terms of reference, sets out the board's overall remit. The board has an advisory role in relation to the work of the shareholder executive as a whole. This will include setting strategic direction in the light of ministerial objectives, periodically reviewing the delivery of objectives as set out in the business plan, and considering any specific issues referred to it by the executive committee. It says this holds true, but more specifically, the board should expect to, and then if we turn the page, thank you, we see some other points there. One of them is review the progress and status of big projects. Projects, is that referring, or would it include assets such as the post office?
Yes, but it's important to remember that the post office, when this was written, of course, was just a division of Royal Mail.
Yes, until April 2012 when it became under direct.
Correct.
And we're going to turn to that shortly, but do you agree with the suggestion here that this also formed part of the board's responsibilities?
Absolutely.
Thank you. That document come down, thank you. At the board level, what role did you see the SHEX board as having in respect of risk management?
Well, as I think has been pointed out by Mark Russell yesterday, it was an evolving process, but it was very clear that the experience level of the shareholder executive at the time that I assumed my position did not have, at that point, the benefit of current risk management as practiced in most major corporations that I was part of. And it became our objective to begin to improve that process. And as you heard, a risk committee was established under Fiona McGregor. And later on, the RAG, or Red, Amber and Green analysis process was commenced and then refined in 2014.
So when you started, you say that it evolved. When you started in your role as chair, what steps did you take as chair, or did the board take, in respect of improving risk management?
We spent quite a bit of time discussing the process as currently practiced at that point in the corporations that I happened to be involved with Mark, and he duly took up the cudgel and went to work on applying those standards, taking advice from some of the corporations that I worked with.
In order for the board to properly carry out its role, did it need to satisfy itself that the executive had identified the appropriate risks for each asset?
Well, as I indicated, it was an evolving process, and just the number and size and complexity of what was being looked at and reviewed at that time was, by any standards, very heavy, particularly in the light of the fact that Royal Mail was being floated and all of those issues around the impact on the shareholders' investment in Royal Mail, nuclear decommissioning, which was costing hundreds of millions of pounds a year, the establishment of the British Business Bank, the Green Investment Bank. So in the context of looking and reviewing the risks around those investments, it depended on the size and scope of the particular investment. And at that point in time, at the beginning in 2012, Post Office would have been well down the list in the context of the perceived levels of risks.
It may help if we ask you questions generally there, but we'll test that as we go through the chronology. I'll stick with a few of the general questions first, though. The first is, did anyone on the SHEX board have expertise in the legal function of a corporate body?
Not specifically.
Why not?
We were not a corporation that was constituted under the Companies Act. We were an advisory board, and as judged, I think, by my predecessor and subsequently reinforced by me, the key was to get a skill set around that board table of great experience, which would complement and supplement some of the lack of experience within the shareholder executive.
2 points there. Firstly, in terms of identifying what the skills required at the SHEX board meetings and who was a member of the board, was that your responsibility as chair?
I inherited a board from the outset, and changes to that board were my responsibility.
When we consider that one of the assets that SHEX was overseeing, Post Office Limited, when we consider that it was prosecuting sub-postmasters, which was a legal function, do you think it would have assisted the SHEX board to have someone with experience of the legal function of a corporate body?
Well, in the context of the board's knowledge, or indeed the shareholder executive's knowledge of what the prosecutions were being, what the impact of those prosecutions were, and at the time, it was very, very limited. In fact, I cannot remember a discussion at any point in time in my tenure on the Post Office prosecutions issues. There was a discussion which was between myself and the chairperson of the Post Office around the key issues that were concerning her at the time. This was the standard type of questioning that I had for each board member that I interacted with. And her response was that it was just some challenges dealing with the sub-postmasters and their union.
We're going to come to that. I assume you're talking about a meeting with Alice Perkins.
Correct.
We'll come to that shortly. Let me, could we please bring up UKGI 30045855. See, this is a letter to you dated the 4th of October 2011. It's your letter of appointment. If we could turn to page 3, please, to paragraph 3B. It says, as chairman, your key role will be to provide high-level strategic direction to the shareholder executive. You don't need to go through all of them. One of them is to develop a constructive, frank and open relationship with the chief executive, holding him, her accountable for the effective implementation of decisions. Did you consider that to be a personal responsibility to hold the chief executive to account in respect of his duties in relation to risk management?
Most certainly.
That can come down, thank you. I want to, my last sort of general topic on Post Office Limited as an arm's length body. Please could we bring up your witness statement at page 3, paragraph 10. Thank you. Oh. Thank you. You say at paragraph 10, the Secretary of State for the Department of Business, Innovation and Skills at the time had ultimate responsibility for the shareholdings in Royal Mail Group and Post Office Limited. The Secretary of State could not delegate his responsibilities. When you refer to the Secretary of State's responsibilities here, what are you actually referring to?
In respect of arm's length bodies.
Could you define precisely what the responsibilities are?
We did not. No, those were defined either in practice or...
Sorry, what I mean is when you're here in your witness statement saying had ultimate responsibility, and you're saying the Secretary of State could not delegate his responsibilities. My question is precisely what responsibilities are you referring to when you write these sentences?
I can't recall the distinction between whether they were actually delineated in writing, but obviously the rules and the overview of how an arm's length body such as the Post Office would be run and managed would have been set out in either mails or statutorily.
Let me ask it another way. When you were writing this part of your statement, what did you think was required of the Secretary of State when you said that the Secretary of State could not delegate his responsibilities?
Well, I believe that the shareholder executive was acting as his agent, if you like, that may be the wrong legal term, in ensuring that he or she, but it was a he, were aware of all of the key issues that needed to be elevated to his level, so that issues that were important, either politically or in the context of funding, etc., were made very clear to him.
If we look maybe at UKGI 30444314, please. You refer to this in your witness statement as the Sheik's Handbook. At page 2, please, right at the bottom. So the shareholder executive model of corporate government. The government intends to operate as an intelligent and informed shareholder. And then if we go over the page, please. How the government intends to operate as a shareholder. So the basic shareholder model as set out below summarises the key actions of the shareholder. And in the box, we don't have to read it all, but you'll see it there. The final one is the shareholder monitors the performance of the business to satisfy itself that the strategic plan is on track and ensure that any interventions required are well informed and appropriate. Are these the responsibilities you were referring to?
Yes, they certainly were among the key responsibilities.
If we can turn the page, please. We have what the government expects of its businesses. Principle 1, businesses should seek an honest, open and ongoing dialogue with the government as shareholder. And Principle 2, businesses should operate a no surprises policy, ensuring that the government as shareholder is informed well in advance of anything potentially contentious in the public arena. As an intelligent and informed shareholder, should the government have taken steps to satisfy itself that the businesses it owned were following these principles?
Well, the government was, through Martin Donnelly, the Permanent Secretary, was assured on an ongoing basis as to where we might or might not have been performing under these requirements, these principles.
I think, let's frame it in another way. If shareholder executives is, I think, using your words, acting as an agent of government, I think that's what you said earlier.
Yes.
You're nodding, yeah. And when it says what government expects of its businesses, let's consider businesses there to be post office. Okay?
Businesses to be?
The post office.
Yes, correct.
Do you think, as the shareholder executive, in managing the government's shareholding function, that the shareholder executive should have taken steps to see that, for example, the post office was complying with principles 1 and 2?
There was no reason to doubt that an honest, open and ongoing dialogue was not taking place between the post office executives and the shareholder executive.
That's a slightly different answer. That's to whether or not what actually happened. I'm asking as a matter of principle whether you accept that the shareholder executive, as acting as an agent of government, as you said, owed steps to satisfy itself that principles 1 and 2 were being complied with.
I agree completely.
Can come down, thank you. Could we go back, please, to your witness statement, page 3, paragraph 11. you say that the Secretary of State, in my view, cannot have been expected to have taken any more of an active role in overseeing the day-to-day operations of Royal Mail Group and/or Post Office. This reflects usual practice. The role of a shareholder is not to manage the operations of a company. There's a difference, isn't there, between managing the operations of a company on the one hand and overseeing the management of a company's operation on another.
There is.
You go on, so nor was it the function of the Department for Business, Innovation and Skills, or SHEX, as an organisation within that department, to be responsible for the operations of Royal Mail Group and/or Post Office Limited. Responsibility for the company's operations was with the Post Office Board, comprised of senior management and independent non-executive directors, including a representative of the Secretary of State through shareholder executive, the shareholder NED. So breaking that down, you say it wasn't the department's role to be responsible for the operations of Royal Mail or Post Office. Is that your evidence?
Correct.
You then say that the responsibility for the company's operation was with the Post Office Board.
Yes.
You say that the Post Office Board was comprised of executive directors and independent non-executive directors.
Yes.
And the responsibility for the company's operation therefore lay with those directors.
Yes.
One of those directors was the shareholder non-executive director, correct?
Correct.
That was a shareholder executive official, correct?
Correct.
That was, and you describe that person as the Secretary of State's representatives.
Yes, correct.
Why then do you say that SHEX and the Secretary of State did not have responsibility for the day-to-day running of the company?
Well, what I said was they don't get involved on day-to-day decisions, nor the normal requirements of management in deciding on investment policy, etc. This is an issue where the Secretary of State, through the full-time appointment of a SHEX representative of the board, ensured that adequate oversight and review was happening.
Yesterday, the inquiry heard evidence from both Mark Russell and Robert Swannell. They agreed that as an arm's-length body, the Minister was ultimately responsible and accountable for the operations of Post Office. Would you agree with that?
I would.
I want to look at some of the specifics now in the oversight of Horizon. Could we look at page 20 of your witness statement, please, paragraph 45? Thank you. At 45, you say that you've been asked, that's asked by the inquiry, whether the SHEX board was informed or had knowledge of the following matters. And in the sub-paragraphs, there's listed various matters, including some documents that the inquiry sent you. You see there's the second site interim report at 45.3, then the Clark advices, and 45.7, there's Deloitte's Project Zebra report. If we turn over the page, please, and have paragraphs 46 and 47 on screen, if we can. Thank you. You say that the matters and documents referred to in paragraph 45 were not raised with the SHEX board.
That's correct.
Now, in paragraph 37, you refer to a conversation with Richard Callard about the instruction of Deloitte. I'm going to come to that later. excluding that, were any of the matters or documents referred to in paragraph 45 raised with you personally outside of the board?
No, they were not.
At 46, if we can just go back up, please. You say, what information is passed to the SHEX board is dependent on what SHEX team and the SHEX CEO deemed to be an issue that required the attention or advice of the SHEX board. It is now clear that the documents referred to raise serious issues in relation to the functioning of the Horizon system and the prosecution and treatment of sub-postmasters. I think that both SHEX and the board should have been made aware of these very significant matters. I can come down, thank you. It may seem an obvious question, but can I ask you why you believe that the SHEX board should have been made aware of those documents and matters?
It became clear, in hindsight, reading the documents now, that there was a lot of there were many issues happening in the context of that relationship with the sub-postmasters, and indeed, although not in absolute volume terms, a huge number of issues being raised in Parliament, though we should have had a mechanism that would have allowed us to be aware of just those factors. Whether it would have led to different advice is something I couldn't comment on.
I mean, is it the fact that the matters raised go to the heart of the operations of Post Office Limited?
They
significant
do.
Issues for its...
Yes, they do.
And on that basis, they pose a significant risk to the business?
Yes, and that's only evident on hindsight. For example, the Linklaters report, which mentioned a risk of 100 million, 0 to 100 million in settlement risk, which was a significant number in reference to the P&L of the Post Office. That should have been flagged.
Can I ask you, how often would you meet people from the Post Office team within the shareholder executive?
My role was to meet with the chairperson, which would be at most twice a year.
Let me just clarify the question, sorry. I'm talking about within the shareholder executive, those persons working on the Post Office as an asset. How often did you...
Most of my time was spent with the chief executive, Stephen Lovegrove, followed by Mark Russell, and the individual team members only as issues arose. So the leader of the team, Susanna Story, or in later cases, Roger, it was more frequent, but on a I should say, an unplanned basis.
When you say as issues arose, what issues are you referring to?
Well, I'm referring in the main to Royal Mail issues at the time.
So the Royal Mail issues, so the company had separated in April 2012.
Correct.
Is that correct?
Correct.
The Secretary of State maintained a shareholding until, I think it was the next year. Is that right?
Correct.
And is your evidence that the Post Office team were dealing with Royal Mail issues still?
No, I'm misleading you. The issue was that the dominance of the Royal Mail issues in the context of what the shareholder executive was reviewing and following up with. It became a major exercise.
For example, you mentioned Susanna Story earlier. What issues did you discuss with Susanna Story?
Well, these were discussed really through the chief executive as to her experience on the Royal Mail board and the Post Office board. And I believe Mark referred to it yesterday, Mark Russell, when he said it was not an easy relationship.
Can you recall any issues relating to the Post Office as a business which you were aware of through Susanna Story?
No.
let's look at your first board meeting as chair, please. It's UKGI 3045852. So we see 7th of March 2012. You're listed as in the chair. If you could go to the bottom, please, of the document. There's an introductory paragraph. And it says, Patrick informed the board that he would step out if there were any discussions on the Royal Mail side relating to Bank of Ireland, as he was Deputy Governor. Did you ever have to do that, step away from a discussion on Royal Mail because of your ongoing relationship with the Bank of Ireland?
Yes, of course, it should say Post Office, because the relationship between Bank of Ireland on the financial services side was with the Post Office. And I do recall, at least on one occasion, recusing myself.
Do you recall what the issue was about?
The financial arrangements of the transaction.
When you say the transaction is...
The agreement between Post Office Limited and Bank of Ireland to supply certain financial services products.
If a person was raising with you an issue about Horizon, which was the system that generated the data on which Post Office put together its accounts and which it provided information to its clients, would you have been able to deal with that or consider it without being in conflict?
Well, yes, indeed. I don't think it would have been a conflict at all.
And why do you think that?
Because the system, the operation system through the Post Office was not really related to the services provided by Bank of Ireland.
Are you aware of there being any reluctance or reticence within the team to discuss issues with you regarding Post Office because of your relationship with the Bank of Ireland?
None.
We mentioned earlier Susanna Story and the appointment of the shareholder non-executive director. Are you aware how Susanna Story was selected for that role?
That was the choice of the chief executive.
Are you aware of whether anyone, well, let's say the chief executive, considered her suitability for the appointment? Or what consideration he applied?
It had already occurred by the time I started, so it didn't arise.
Could we look, please, at page 19 of your statement, paragraph 43? You say, following Post Office Limited's separation from Royal Mail, its status was raised to priority level. Post Office Limited had been a division of a major asset, and now it was a major asset in its own right, receiving substantial levels of funding from the government, and so it was wholly appropriate for SHEX to take a more direct role in its government. When you say it was raised to priority level, what did that mean in practical terms?
In practical terms, it probably meant that it was more visible within the portfolio.
Visible to whom?
Visible to the shareholder executive management, And in respect of peer reviews, for example, within the shareholder executive, it would have been under much greater scrutiny than it had been as a division of Royal Mail. They're the points that strike me most of all, I think.
Was it raised as a priority for the board?
No.
Why not?
In the sense that it was reported on occasionally in the time that I was in charge. There was no change in intensity in the sense that Post Office was not perceived at that time to be an issue of concern, of great concern.
So that's probably a good time for the afternoon break. If I could ask that we come back at past, that'd be grateful. Thank you, sir. So can you see and hear me?
Yes, I can, thank you.
Please could we bring up UKGI 30-16711. It's a minutes of a board meeting on the 8th of May 2012. You say in your witness statement that you're satisfied that these minutes accurately record the discussions at the various meetings.
Correct.
So this is the first meeting after Post Office Limited becomes independent of Royal Mail. Is that right?
Correct.
And so in terms of the, as we discussed before, the governance shifted in that for the first time the shareholder executive and the Secretary of State were directly, had a direct line essentially into Post Office Limited.
Correct.
And is it fair to say that previously, as Royal Mail Group, as part of Royal Mail Group, the shareholder executives' visibility of the risk to Post Office Limited were not clear, should we say?
That would be absolutely a fair description.
If we turn to the page 2, please. If we go down to Royal Mail, thank you. Item 4, we see Royal Mail is discussed over the page, please. It talks about state aid approval for post office funding. And then 4.2, board members discussed the transaction, specifically points around a trade sale versus IPO, employee shares, and the mutualisation consultation for the post office in union interest. It doesn't appear that there was any discussion on, or a deep dive, as it were, into the risks of Post Office Limited as an asset in itself.
Correct.
Or, in fact, to the corporate governance of Post Office now as an asset.
It would have been too early in the life of the Post Office as an independent business to do that at that time.
Do you think at some stage that should have been done by the shareholder executive?
Yes.
And by the board?
Yes.
How long should it have waited until?
Probably 18 months after establishment.
Why at this stage, when it was a business that had been running for a while in terms of the actual business of the post office, why was then not the ideal time to analyse what the risks were to the business?
The structure of the spin-off of the post office from Royal Mail was one where it was business as usual for the post office. There were no major changes in its operating procedures.
But wasn't this a time when, after not having visibility of the post office, SHEX now had visibility and could understand the risks that that business had? Why didn't it do that?
Well, as I said, I think some period of time after its official foundation would have been more appropriate.
Would you accept that the board should have done a risk or a deep dive or a risk assessment of Post Office Limited within the first 6 months, say, of separation?
There were no reasons at that point in time visible to the board or to the SHEX executive that would suggest that such a deep dive was required.
How did the board know that? How could the board satisfy itself that that was an appropriate course of action without having done a deep dive of what was effectively a new relationship with an asset?
Well, you'll have seen the split of the categorization of the various parts of the portfolio. And at that point in time, we had just appointed the first shareholder executive representative to the Post Office Board. That person and the whole organization needed time to bed down.
On that point, can we look please at UKGI 30193348? These are minutes of the Post Office Limited board meeting on the 23rd of May 2012. Can we turn please to page 4? The inquiry, if you can go down please. Thank you. The inquiry asks you to consider the entry at POLB 12/60, and your evidence was or is that you didn't see these board minutes at the time.
Correct.
If we look, Susanna's story here is outlining the reasons for representation of Shecs on the board of Post Office Limited, and we see that she says at the end of paragraph A, she clarified that she would not be sharing the board papers with her colleagues at Shareholder Executive. Was that something you were aware of?
No.
Given this, the role of the shareholder non-executive director was so important in oversight of Post Office Limited, should the board of Shecs have been aware of this position?
It would have been perfectly reasonable for the chairperson to have requested that board papers did not go outside the boardroom, whether it was for the post office or for any other public company. However, there was nothing to prevent Susanna from communicating the essence of what the board meeting and what the board papers were saying.
But why wasn't you as chair and the board aware of what appears to be quite a significant self-imposed restriction on sharing board papers?
This is nothing unusual in the context of normal board practice.
So, is it your evidence that the board of Shecs didn't need to know about this?
At that point, no.
So how could the board understand the flow of information from its assets, such as Post Office Limited, to their board?
Through Susanna as the representative.
What steps did you take to satisfy yourself that Ms. Story was discharging her role as shareholder NED effectively?
She was highly regarded within the shareholder executive. She was one of the most experienced members of staff at that level, and of course much of this too would have been a learning experience for her, as well as everybody else appointed to such positions.
Shortly after that meeting, Second Sight were instructed to address concerns raised by members of Parliament in June, July 2012. Were you aware of that at the time?
No.
The MPs represented sub-postmasters, some of whom had been convicted on the basis of data generated by the Horizon IT system. Were you aware that there were such convicted persons?
I was not.
Second Sight's terms of reference were to consider and to advise on whether there are any systemic issues and or concerns with the Horizon system, including training and support processes, giving evidence and reasons for the conclusions reached. So, effectively an investigation into Post Office's front-end accounting system. Do you agree?
Yes.
And if Second Sight had found any issues with that, any problems, that would have been significant to the Post Office?
It would.
Firstly, there would have been, or there could have been unsafe convictions if they'd found issues. Do you agree?
With the benefit of hindsight, absolutely.
Secondly, the data on which Post Office produced its accounts would possibly be unreliable. Would you agree?
There's always a possibility that depends on the impact of what the judgment was in the context of the financial impact on the balance sheet and P&L of the Post Office.
At paragraph 31 of your statement, you refer to meetings of the board on the 11th of July 2012 and the 12th of September 2012. And you say there was no reference in those minutes to the launch of the second site investigation. Why was such a significant issue not raised with the board? Can you assist us with that?
Well, as I think, with hindsight, it is clear that these matters were believed to be business as usual, and it was an internally sponsored inquiry.
It might be a surprise to some that the chair of the body of SHECS with responsibility for overseeing Post Office wasn't aware of the second site review. With hindsight, where do you think the problem lay in this not being raised to the board?
I believe that the modus operandi of the Post Office management team was the assumption that the system was adequate and did not have systemic issues. It may have been a self-reinforcing view that they took and their approach to any review of the system as a consequence.
Do you think you should have taken more interest in the Post Office itself as an asset?
I think that interest grew significantly as time progressed. Perhaps with hindsight now, the answer is probably yes.
When did it grow, your interest?
It grew over the 2 years that I was, 2.5 years that I was chairman.
And what caused it to your interest to grow?
The size of the request for government funding, the nature of the political decisions around, sadly, not the ones we're discussing here, but rather the issues of Post Office representation around the country, the ownership of last mile in delivery and postcodes. Those issues became very important.
So as you gained more interest and became more involved, can you help us with how you, as you say in your statement, you remained unaware of issues such as the prosecution of sub-postmasters?
Can you say the question again, please?
Yes, so as your interest grew, and you took more of an interest in Post Office Limited, can you assist us with how, when you were discussing Post Office with people, you apparently remained unaware of issues such as prosecution of sub-postmasters?
I think I said at the beginning that these issues were regarded as business as usual by Post Office management. In that sense, there was no evidence of urgency around it, nor that indeed it might be severely damaging.
You referred to in your statement biannual meetings with the chair of the Post Office, yes?
Correct.
What was the purpose of those meetings?
My role in taking over the chairmanship was to bring corporate experience to bear on the review of portfolio companies. I'd had a lot of that experience in prior roles as chief executive and subsequently chief financial officer of financial institutions. We instituted what was called a fireside chat review with the chairpeople, where there was an attempt to create an atmosphere that was non-threatening so that they could express, without fear of retribution, any issue around their major concerns. What the question normally phrased was, what keeps you awake at night? It never came up in that context.
And just so we're clear, when you say the concerns, is that concerns in relation to the concerns with the business, so concerns in relation to Post Office Limited, or concerns in relation to how SHECS was overseeing the business?
All of the above.
You say we don't need to bring it up, that in one of the meetings with Alice Perkins, it's page 14, paragraph 31.2, if you want to review it, you say that you remember Alice Perkins mentioning, almost as a passing comment, that there were a small segment of difficult sub-postmasters and ongoing difficulties with the union.
That's correct.
Did you ask any questions about those difficulties?
I can't recall what the substance of the conversation was, but it was very much in the vein I've mentioned of this is just business as usual. We're getting on with it.
Did you discuss those issues with anyone at shareholder executive?
Mark Russell and I had some conversations about the effectiveness of the post office management, which was, some of my concerns were that they could have been doing a better job.
Who within post office management?
That's the chairperson and the CEO.
So you had a conversation with Mark Russell about whether they could have been doing a better job?
And that is normal. We did this with all the portfolio management team.
And what were your concerns with the chair and the CEO?
In particular, in the context of the chair appointment, which preceded my time in Checks, I had a concern that Alice's experience was not particularly suitable to the role of chairing businesses of this nature.
What were the basis for those concerns?
My personal experience.
And what about Paula Reynolds? What were your concerns?
No, those were more in the nature of the points raised, which led to a review of her performance later on.
What were they?
I can't recall.
When you were having meetings with these fireside chats, as you described them, were you briefed by anyone at shareholder executive prior to the chat?
Yes, by the portfolio individual responsible.
As part of that briefing, did no one raise with you the second site review?
No, they did not.
Let's move forward in the chronology. We have the second site report that's published, the interim report, on the 8th of July 2013. My understanding of your evidence is that this wasn't discussed at board level.
That's correct.
And your evidence is you weren't made aware of it.
Correct.
Were you made aware of the involvement of the CCRC in investigating past convictions of sub-postmasters?
I was not.
I want to look at one matter in particular where you say you do have some knowledge. Could we bring up, please, page 20, paragraph 45 of your statement? Sorry, page 21, paragraph 47. So we've been to paragraph 46 already. It's where you discuss your knowledge of various documents. Paragraph 47 says, I should add that I recall a conversation with Richard Callard in which he referred to Deloitte having been instructed to conduct a review to give assurance in respect of concerns raised in Parliament. I recall saying to him that I had experience of Deloitte and would recommend them. In what context was that conversation with Richard Callard?
He was the head of the team at the shareholder executive with responsibility for post office. And in my normal occasional conversation with those positions, those people in those positions, I tried to impart some of my knowledge of who would be the best people in the context of an external review. It was at that point I had never heard of Second Sight, had no experience of them. So I tried to press on him that the Deloitte team would be best equipped to do the kind of deep dive required to determine what the issues were. As it turned out, they did a desktop review.
Did you ask what the issues were that were to be investigated?
He mentioned they were around the Horizon system at that time. The systems, quote unquote.
Did he refer to the fact of sub-postmasters being prosecuted?
No, he did not, to my memory.
You say that he said it was to review to give assurance in respect of concerns raised in Parliament. Did you continue to believe that it was business as usual at this stage?
Yes, I did.
Would you consider it to be business as usual for a business to face concerns raised in Parliament about its accounting software?
It's highly unusual, and looking back on it with hindsight, there was a level at which the inquiries, or rather the issues, and being raised by MPs, had risen to a volume that should have been brought to the attention of the shareholder executive in the first place, and possibly to the board after that.
Well, if we bring up your witness statement, please, at page 22, paragraph 50.
While that's being done, can you give me some indication of the year in which you think you had, in which you had the conversation with Mr. Callard? I.e., was it towards the end of your period or some other time?
Yes, sir. It was towards the end of my period, about April time.
Yeah, April 2014. Yeah.
Yes.
Right, thank you.
In these paragraphs, you're saying you're commenting on things that you would have handled differently and giving reflections. In paragraph 50, you say, as a learning point, you said, I believe that it could have been helpful for SHEC's board packs to have a schedule of significant issues raised in Parliament relating to government assets where SHEC's handled the shareholder role. Well, the fact that Parliament was concerns had been raised in Parliament was raised directly with you by Richard Callard. Why did that not set alarm bells ringing as to the significance of this issue with Post Office Limited?
Most probably because of the timing. In other words, the reviews were just in the case of Deloitte beginning rather than at the end. And I had not had any knowledge of the Second Sight interim report.
Do you think at this stage you should have asked more questions on the background to the issue?
Perfect hindsight, absolutely.
Well, not with hindsight. If you're told that there are assurances there are concerns raised in Parliament about a business that shareholder executive is overseeing, do you think, with the information you had at the time, you should have asked more questions about it?
I think the level at which the number of questions being raised, it started in the single figures and then eventually rose to 47, I believe, by about this time. 47 is certainly a number that should have been raised.
47 what? Sorry, I missed.
47 specific questions in Parliament from different MPs about the Horizon system.
That's a slightly different question. I'm asking, at the time with what you knew, should you have asked more questions of Richard Callard or the shareholder executive team once you've been told that Deloitte were involved and there were concerns raised in Parliament?
At the time, I felt I addressed the issue satisfactorily.
Let's look at the board briefing, please. It's for the Deloitte report. It's POL 30-28069. You've had a chance to read this in preparing for your witness statement, and the inquiry's seen it several times, so I'll whistle through the key points. Can we look at page 3, please? And at the bottom, limitations and assumptions. As you said earlier, it's a desktop report, so it says we have not validated whether Horizon has been implemented or operated as described in the documentation reviewed. Second bullet point refers to significant gaps existing in the information available. If we go to over the page, please. See, it says the documents the assumptions include that the documents provided are a complete and accurate representation of the Horizon design. And finally, assertions made by Post Office Limited and Fujitsu staff have been accepted as accurate without corroboration or verification. Those are quite significant assumptions, aren't they?
They are.
Could we turn to page 7, please? If we go down, stay there for the moment. Matter 3, the issue is baskets of transactions recorded to the audit store are complete and digitally sealed to protect their integrity and make it evident if they've been tampered with. We don't need to go through all the detail, but if we see the third bullet point down, the final sentence, this could allow suitably authorised privileged staff in Fujitsu to delete a sealed set of baskets and replace them with properly sealed baskets, although they would have to fake the digital signatures. Now, we have not identified any documented controls designed to prevent a person with authorised privilege access from deleting a digitally sealed group of data and replacing it with a fake group within the audit store. And then over the page at 8, please. Down to matter 5. Balancing transaction process. This is an emergency process accessible only to restricted individuals in Fujitsu, which can create transactions directly to branch ledgers. The process creates an identifiable transaction in the ledger verbally asserted by post office staff to be visible to sub-postmasters in their branch reporting tool, but does not require positive acceptance or approval by the sub-postmaster. The use of the process is a full audit trail monitored by Fujitsu, and it goes on to say some various assertions. And then finally, over the page, please, it refers again to the balancing transaction processes that are controlled by Fujitsu via formal change control and monitoring processes. An audit trail is retained over the use of this process, and since 2008, when reporting became easier, it is asserted by Fujitsu staff that the audit trail is monitored by a Fujitsu department independent of those with access to the function also in Fujitsu. The degree of formality over this monitoring and its frequency is unknown. It goes on. If this report had been put before the board, as in your evidence you say it should do, what action do you think would have been taken by the SHEX board?
We would have pointed out that a desktop review in the context of everything that had been written warranted a full-blown analysis of what was going on with the system.
And when you say warranted a full-blown analysis, what precisely do you mean?
We've been going into a deep dive and audit of transactions from start to finish, and the fallout or implications of those actions where there were, for example, discrepancies.
If the if the report was before the board, we've heard from witnesses, you may have, I think you listened to yesterday's evidence about the degree to which oversight was exercised by the shareholder executive, or I think people refer to arms lengthening or shortening. Would this report have led to a shortening of the arms in terms of oversight?
Most likely would have.
Please I'll move on and look at a matter in your statement about shareholder executive. Page 12, paragraph 30, please. You set out in paragraph 30, the various structures that were in place to oversee Post Office, which we turn to, I don't need to read out. You say, I believe that there was a governance structure in place that provided an appropriate level of oversight of Post Office. Does that remain your belief?
It does.
How do you reconcile that with the fact that you say the board weren't aware of the significant issues referred to that you say it should have been aware of?
Because the oversight function is a two-way process. It's both bottom-up and top-down. We were in the top-down role as the shareholder executive. The bottom-up process of understanding the risks, the importance of those risks, the significance of them, and bringing them appropriately to the Post Office board failed.
Could we look, please, at UKGI 30-16718? This is a board meeting on the 16th of July 2014 of the shareholder executive. You're in the chair, and Robert Swannell, who gave evidence yesterday, who became chair in September, was also in attendance, marked as RS, your POS. If we go down to risk registers, the board agreed that the revisions to the risk register were a significant improvement, and it says that at the end that you summarise that the key aim of the risk register should be to provoke questions and cautioned against making further significant changes. What significant changes were you cautioning against?
I can't recall what was being proposed at the time, but at this point we had implemented the colour coding and the heat map, and that was best practice in industry at the time.
Were you satisfied with the process of risk management in checks at this point?
At that point, yes. With hindsight, clearly there were some shortcomings.
Please, can we bring up your witness statement at paragraph 50? I want to look at some of the recommendations that you suggest. It's page 22, sorry, I should have said. So we've been to paragraph 50 already. It's where you say you believe it would be helpful for the Shecs Board Pack to have a schedule of significant issues raised in Parliament. Do you think that would add anything additional to a well-run risk management process where risks were identified and brought to board level?
It might, it may not, in the context of a risk management system which cascaded the key issues to the correct levels. It might have been an extra additional burden on top of that process if it was working effectively. However, here we have a situation where the government is at arm's length from the shareholder, in other words, is at arm's length from the business. But we have a responsibility on behalf of the owners of that business, who are the citizens of this country, and their representatives in Parliament, who, when they raise issues of significance, and that's the key difficult item to define, what is significant and what is not, that process should, the full circle should occur, which brings it back into the realm of the government bodies charged with looking after those investments.
Does there need to be better communication between the department and, oh, sorry, let me rephrase that. When you were there, do you think there needed to be better communication on issues like that between the department and Shecs?
I never had the impression that I didn't have sufficient time or not discussing the right issues with both the Permanent Secretary and the ministers.
Paragraph 51.
Before we get to 51, Mr. Stevens, in terms of the schedule of significant issues raised in Parliament, I suppose the advantage of that is that it takes away judgment about risks, i.e. if something is significant enough to be raised in Parliament, it's significant enough for you to pay attention to it.
Well, sir, I would expect there would be a healthy tension between the risk register in Parliament and the risk function in the underlying businesses.
Exactly so, yeah. Sorry, Mr. Stevens.
Not at all, thank you, sir. Paragraph 51, you say, in addition, I would like to have raised as a query at Shecs Board level the way in which Shecs teams received and challenged information received from government assets, as I believe it is now clear that there were deficiencies in information flow within Post Office Limited and up to Shecs. What type of queries did you have in mind when you were drafting this statement?
Well, I'm referring to the risks, the whole horizon issues, and whether these were being surfaced at the right levels in the underlying asset, in this case, Post Office. So corporate practice, I might add, was in constant change in the previous 10 years to this, where a lot of risks were inadequately addressed in many corporations. Or you only have to look at the failures, but we won't go there, of public corporations. This was an ongoing exercise to improve how you raise the issues and who signed off on raising those issues, so there was accountability for raising the issue and being held accountable that the issue was properly addressed in due course.
So if you were thinking about what chairs of businesses or bodies should do in future, what type of queries they should be asking, what springs to mind? Well,
boards are entirely dependent on management and the experience of the board members. It becomes a really critical issue in the case of the Post Office Board, whether they had the right mix of skills to properly challenge internal audit, legal, risk management on the issues. And that is, of course, where some of the weaknesses can appear.
The inquiry will hear in the coming weeks from witnesses who make other recommendations. One suggestion that will be made is that there should be a change in the law to empower a minister to become directly involved in the decision-making of the board of a company such as Post Office. What would your view of that be?
I think my view is that ministers have total authority right now to investigate anything they wish to look at. And it might be superfluous.
So that concludes my questions. I think there are two sets of core participant questions. One from, how long? There's 5 minutes from Howe and Co. and 10 minutes from HJA, Hodge Jones Allen. So that should bring us to a close within time.
Good. So I shall look forward to the discipline of the advocates in ensuring that, Mr. Stevens.
Shall I go first? Mr. Sullivan, will we act for Alan Riddell?
Mr. Jacobs.
Sorry.
Start now.
We act for Alan Riddell, who is a sub-postmaster.
We act for Alan Riddell, who is a sub-postmaster from Sunderland, and he's travelled down here today with Jean Smith, his wife Carol, who is watching, I understand, remotely, is unable to attend today. Now, they were involved with the East Bolton Post Office, and their Member of Parliament, Stephen Hepburn, wrote to Ed Davey as a minister in February 2012, they say that they never received a proper reply beyond a simple acknowledgement. Now, you say, at paragraph 36 of your statement, that you had no involvement in this particular case. And at paragraph 38, you say the messaging from Post Office through the Shecs team was that Horizon was robust, Poll was addressing matters including by way of the second site review, and the Shecs team considered that this was an operational matter for Poll. Is that your understanding of where we were at the time? So it follows then, doesn't it, that it was your understanding that the Shecs team was informed and instructed by Poll, Post Office, in relation to complaints that were escalated or being attempted to be escalated to ministers through MPs.
I would not have had any sight of those issues.
No, yes, but what you've said is that it was because of the messaging from Poll, which was being communicated to the minister via Shecs. So you were aware of the messaging from Poll, weren't you?
Yes, that was a normal. This is, in effect, a sort of a dual mandate for the shareholder executive to communicate back to the minister and to help and assist the arm's length business with that exercise.
Mr. Rose, what I want to ask you then is in relation to paragraph 37, Mr. O'Sullivan. You say if the issues being raised by sub-postmasters with Horizon and the associated ministerial complaints had been flagged as significant or as a significant issue by the Shecs team, I would have expected to have sight of it. Is that your understanding? So what sort of complaint made by a sub-postmaster or sub-postmistress communicated through a Member of Parliament would have amounted to a sufficiently significant issue for you to get involved, Mr. O'Sullivan? What would you have taken?
The reality in these situations is that it might have been communicated on the basis of complaints about the effectiveness, or rather the usefulness of the IT system. That would be a normal operating issue, and not one for the board.
So that sort of complaint would get through to you?
It would not, normally.
Well, what would get through to you was my question.
Well, it's very clear now with hindsight that as the issues of complaints arose about the process used with the sub-postmasters to prosecute them, and to prosecute them as part of the Post Office's remit, which was different than handing it to an external counsel to do it, that sort of issue should have been raised.
Should have been. But what you said in your statement is that that complaints, ministerial complaints, if they were flagged as a significant issue by SHEX, those are the ones you would have expected to have sight of. And I'm not talking about with hindsight, I'm talking about back in 2012 and thereafter. What was a significant issue that would have led to you
at that
having
point in
sight
time,
of it?
a threat to the financial performance of the post office?
So there's nothing really, it seems, that a sub-postmaster could have done to have gone over the heads of the post office, to the owner of the company, to the minister. There's nothing that really would have got to your attention. Is that what you're saying?
It's difficult to see how that might have happened, but that's hence my recommendation that there would be a risk register within Parliament to back to the owner.
And do you accept then, I think it follows, that when sub-postmasters, such as my clients who sit behind me, when they sought to escalate their cases to the minister via their members of Parliament through the democratic process, it was the shareholder executive who blocked those attempts, wasn't it?
No, I would not agree with that.
Well, your statement says that these were considered to be operational matters because of the messaging from Pol, so they didn't get through.
But in the context of the Post Office Board, who had the responsibility to determine the significance of these issues, along with management, executive management, it was not SHEC's role to second-guess at that point what the Pol Board was doing.
You will, I no doubt, have been following the evidence in the inquiry.
Correct.
And you will have heard perhaps the evidence in the human impact hearings from sub-postmasters.
Like everybody else, I regret them deeply.
And these are all significant matters, aren't they, that everybody has raised, all of the
indeed.
sub-postmasters. So these issues were in the public domain. Do you accept that when sub-postmasters try to use the democratic process, MP, minister, to escalate their complaints, the shareholder executive should have let them do that, should have let the minister?
The shareholder executive did not stop the complaints from Parliament reaching either the ministers or the Post Office Board.
Well, they advised ministers that these were contractual and operational matters.
Contractual in the context of the day-to-day operations of the business. As the significance of them grew based on the circumstances, independent judgment at that time might have judged differently as to how operational they were or how significant they were.
Isn't the reality of the matter that if the shareholder executive had said, our advice is these are probably contractual matters, probably operational matters, but these appear to be significant matters and the minister should look at them if the minister feels that would be the right thing to do. That's the advice that you should have given, isn't it?
If we had had the information, absolutely.
And you no doubt accept then that the shareholder executive, in not giving that advice, failed sub-postmasters who tried to escalate their cases to the minister.
I respectfully disagree. I repeat that the issue is what information the shareholder executive had to be able to make those judgments as to complexity, importance, or significance from a post office perspective.
Thank you. I don't have any further questions for you.
Mr. O'Sullivan. You were appointed in 2011. Can you help us when that was?
I believe it was October. It's on the appointment, appointment letter from my predecessor.
Let's take it as October then, Mr. O'Sullivan. So that would be October 2011.
I think, Mr. Henry, just to help, his witness statement says appointed October 2011, started March 2012.
Thank you very much, sir. So October 2011, coincidentally, there was an article in Computer Weekly which said 85 sub-postmasters seek legal support in claims against the post office computer system. Throughout this inquiry, we have seen from inside the post office, and obviously not necessarily SHEX, because that was different, but inside the post office, an obsession with the media and how the plight of the sub-postmasters is being portrayed in the media. Were you aware of that background?
No, I was not.
And so it follows that before your appointment, the 6 stories in Computer Weekly, I can go through them if you like, the BBC News programmes, etc., none of that permeated your consciousness?
Correct.
And during your tenure, which was from March 2012 to September 2014, we've got 10 stories in Computer Weekly. You were presumably not made aware of those either.
That's correct.
Right. Could we go to UKGI 000 16739? And while that is being put up on the board, you would accept, sir, would you not, that the vital thing in any flotation is that the listing particulars in the prospectus are completely accurate, that you get a warts and all, forgive that expression, but a warts and all picture of the business, so that anybody who wishes to subscribe or take up shares is fully acquainted with proper risk.
I agree.
Right. So this is a SHEX board meeting of the 13th of March 2013. And at page 17 of 39, we go to the proposed flotation of RMG. And it's noted that a number of critical transaction enablers have been confirmed in the last 2 months. I omit words. And then further down, we can see, if we go to number 3, on the basis of this work, we're now in a position to recommend that we should pursue a sale of shares. We should prepare for an IPO in autumn 2013. And then over the page, at page 18, we have key risks. And we've got industrial relations, this is under paragraph 5, financial performance, investor appetite, market economic conditions, regulation, and then going over to page 19 internally, but 18 on the document itself, we've got at paragraph 6 at the top of the page, these risks are significant and there remains a strong possibility that one or more could materialise. We are continuing to assess contingency options should this be the case. However, at this stage, we and the Union Bank of Switzerland remain of the view that a sale should be feasible from autumn 2013. Now, the position, as you say, however, if I may be forgiven for making an observation, improbable it is, that you had no idea about the noise, as it has been contemptuously described, generated by the sub-postmasters. But the position is that the risk of historical prosecutions, of sending innocent people to prison, appears nowhere in this document.
That's correct.
You would surely agree with me that if that had been a known risk, it would have killed the flotation completely.
I couldn't necessarily agree with that, because
why not?
The analysis would, and the rebuttal might have been sufficient to mitigate what was perceived at that time as an unlikely event.
So in other words, it would be compounded, because there would be therefore a false denial of accountability, and down the line there would be, when this all blew up, there would no doubt be recriminations that it had been wrongly priced.
If the board was entitled to look at the Linklaters, I believe, review, which categorically stated that the probability of loss from the postmaster's actions was low, although it could be 100 million was the number. That should have been stated.
Categorically is somewhat overstated. It was a very, very highly caveated report, was it not?
Well, in reading it post the event, yes.
Yes. May I ask you, were you aware that people from your department were trying to remove, people from Shecs were trying to remove what were perceived to be adverse or critical remarks about Horizon from the prospectus.
I was not.
And so therefore it follows that you cannot have been aware that the Chief Executive Officer of the Post Office, when the officials at Shecs had failed, intervened and actually had what was perceived to be damaging and critical material of Horizon removed from the prospectus.
I was not aware of that.
That would be, on any view, given what we now know, contrary to the whole principle of candour and transparency so far as risk. Do you agree?
You could reach that conclusion?
I'm grateful. Thank you.
Thank you, Mr. Henry. And thank you to everyone for bringing this afternoon's proceedings to a timely close. I'm grateful to you. And I'm also grateful to you, Mr. O'Sullivan, for making your witness statement and for coming to answer questions at the inquiry this afternoon.
Thank you, sir.
Right, so we won't sit tomorrow and we'll resume on Friday.
That's correct, sir, yes.
If I take it, Mr. Stevens.
Sorry, sir, I spoke over you then.
No, I take it at 9:45 on Friday.
Yes, 9:45, thank you.
Fine, thank you all very much.